Good morning, good afternoon, good evening, students. This is Soumya Mahajan. I'm qualified company secretary and I have completed my CS professional exams in the year 2019. Probably after that, I'm having a practical experience working as a whole-time company secretary and a compliance officer in one of the leading PSU right away. So coming to the subject now, I would like to tell you that I would teach company law. Company law and practice. This is in executive and the professional program, both. This is one of the very important subject in both the professional and the executive level. So you need not cram the provisions of company law, but you have to learn it practically, how practically things work. So being a qualified company secretary and working in one of the leading PSUs, I would be able to tell you that, how things work as per the provisions in the practical scenario as well. So coming to your subject, this I would be taking your company law and practice from today. This is very first lecture. Need not worry about first day. Don't get worried. Yeah, ma'am is teaching so many things first day. We'll keep this first lecture very light. Probably in this lecture I would like to highlight on one of the important chapters, what all subjects, what all chapters in the subject will cover first, and then how much time we will take for understanding, giving the time for revisions and the test series. So most important, students, in company law and practice is giving your test series and taking your revisions. Revisions is paramount. Even if you have completed the syllabus 1 month or 3 months back, but your revisions should be at least, minimum time I'm saying for the revisions should be 1 month for this subject. Because see, if you are very good in company law and if you have learned and if you are very good in understanding the provisions in company law in executive level only, you would be able to crack the professionals very easily. Why I'm saying this? Because all the theory subjects in your professional level is interconnected with this subject. So if you have studied this you are very good in understanding the concepts of company law from executive level only, I am damn sure that you will able to clear your professional subjects also. Feel free to ask your doubts. We are in Ramesh Academy. We as a faculties are here to help you anytime at 24/7. You can just drop the query through email or whatsoever is the procedure. I will let you know in upcoming classes, and then you can drop your queries after any class. You feel free to ask even the silly questions. We are here to help you in Ramesh Academy. So I welcome you all once again to this company law and practice. Let's make this subject very amazing, very I want the students to be very enthusiastic in the subject. Why? Because you are a company secretary, upcoming company secretaries of India, so you have to be very vigilant and very you have to be very confident of the provisions in Companies Act. Why? Because you are a qualified company secretary and a whole of the management and the higher top level management, you must say, board of the directors, they will ask the provisions from you. Why? Because you are a company secretary, and if you don't know and you are not confident, and maybe it will not help you out in your career. So why to waste time? Let's start with this is your study material. I would like to focus only on your module. So if this module is very important throughout your executive, throughout your professional. If you are very, and suppose what is the procedure to go through module? See, module is so many pages are there in module. You cannot cram each and every word, you cannot cram each and every line. What you have to do is para by para, you have to understand what is the provision. If suppose any facts facts relating to that provisions come in your examination, suppose case studies come, how you have to present it and how you have to interlink this particular provision with the asked questions. So without wasting any time, let me tell you. First of all, I would like to highlight very important things. The first is just a second. So there are two type of questions in your examinations. First question in your examination would be case laws, case study base, case studies. Second is very theoretical questions, right? So for theoretical questions, you do not have to write a paragraphs. Whatever, suppose a question come, explain what is ultrawise the company. You just have to explain what is ultrawise, how this ultrawise word has come into enforce, from where it is derived from, it is a Latin word. Explain what is the meaning of ultra, what is the meaning of virus, everything you have to explain, and explain with the example as in case study, right? This is how you have to present. Then then comes case studies question. Case studies questions you will get 80% and this is 20%. 80% of your questions of this subject will be covered from case studies. How you can answer case studies now? This is the main important question. Case studies, I already told you, there is certain format in how to present your case studies based questions. What are the facts of the question? What are the facts of the case? So and so, ABC, management, whatsoever the question can be. Facts of the case, yes. Bullet by bullet. 1 bullet, 2 bullet, 3 bullet. This will be facts. You can write down simultaneously how to present the case studies. Facts of the case first. Then comes second, provisions. Applicable. This is how you will present to case. Bullet 1, 2. What provisions I have taken? I have taken so and so section. Section number 52. Explain so and so. Now, provisions relating to case. How the above mentioned provision is related to the case? Now you will explain this. Why? In the given fact of the case study, it is written, so and so is written. How can you can relate this section with this? Then fourth comes your conclusion. Okay, so this is how you can present facts of the case. Okay, this is how it is. So understood? I hope that you guys understood. Like there are two types of questions which can be asked in the subjects for you people: case studies, and next is theoretical. Theoretical 20% will come. You just have to write a simple paragraph. Better write points instead of paragraphs in this examination. You are giving a professional level of the examinations and only hardly 3 or 4% results come. So you better write in a bullet form so that examiner at the time of checking your paper, he need not, and there is a one psychology of the examiner that he did not want to read whole of the paragraph. Instead, if you have given highlighted some of the important words also, it's very important for it will give good impression on examiner. Yeah, the presentation is very good. So make sure you write a bullets in this also. Okay, so case studies comes, theoretical questions come. So case studies, I've told you, this is how case study. Facts of the case, provisions applicable to case, provision relating to the case, how the provisions relating to particular case study, and next is the conclusion. This is how you will present. Now I've just given you a brief how the things, how questions, and how well you can manage your exams, how you can crack your examinations. I hope everyone will score very good and fly with good colors by clearing this exam. And this, if you will clear this exam, I'm telling you, in professional level also, same paper and simultaneous other papers are interrelated to this exam. So you have to be very, very particular about this exam, how you are giving and how you are presenting. Okay, so I will give you 5 minutes, 2 minutes maybe. So yeah, 2 minutes to just write it down. This is very important. Just write it down in your very first page of your index only of this module, so that you come to know how the questions can and how you will present it. Okay. So let's come to very first chapter now. The first chapter, it is very easy chapter, and I will tell you this is very theoretical chapter. Maybe theoretical based questions will come from here, not case studies questions. Case studies very less, 10-20% of it can come. Yeah, there are certain important aspects in this chapter. From that you can just mark down those case studies based that paragraphs. I will tell you how, which portion will come the case studies portion. Okay, so without wasting any time, this is our index, students. This is 19 chapters we have to cover, out of which I will just start with introduction first today, introduction to company law. Okay, so we would cover first starting from section number 1, introduction to company law. See, this is very important. This is small chapters. These all are small chapters. We will cover these chapters in last. These chapters will be covered after covering this first and second. Third will be this, and fourth will be this. This is how the things will. Section 2, part 2 is very, very important for your examination point of view, both in executive and professional. Professional also very important. Okay, so just let us start with very first chapter. So this is introduction to the company law, which is lesson number 1. Okay, see, first of all I would like to tell you one thing. I will clear this first of all. Just a second, bear with me. So introduction is the first chapter. I would like to tell you, in the very first chapter, introduction, first of all, who is this MCA? It is Ministry of Corporate Affairs. What is this authority? Who is this authority? Ministry of Corporate Affairs is all the laws, all the company related laws. This is the authority who takes care. Ministry of Corporate Affairs. If you are very much aware of the recent amendment that has come across, it is V3 version. The Ministry of Corporate Affairs was using in their website V2 version 2. Now it has been upgraded to V3, which has helped many companies to fill their forms. See, there are many annual forms, quarterly forms, and the quarterly forms, the normal day-to-day forms that needs to be filed in Ministry of Corporate. This www.mca.gov.in is the official website through which we can file the company forms. This is the important, all the circulars, all the notifications, I must tell you people, all the notification, all the circular, all these company law bare act, you can find through this official website. So you are now you are upcoming company secretaries, you must know about this website. MCA, Ministry of Corporate Affairs, is the leading authority of our act. Okay, so so I would like to tell you how company law comes into effect. Company law in India, it is, it started from the Joint Stock Companies Act 1844 in England. So the first Companies Act was passed in India in 1850. So first is 1850 when the Companies Act came into enforce. Then simultaneously after that 1866, 1882, 1930, 1956, 1956 and now 2013. So one more thing now. Next thing is, see, 1956 is the very recent Companies Act. I mean, the earlier Companies Act. Many companies have formed in the companies in the year 1956. Now, which has been amended to 2013. All the companies which are formed now, they have to get registered under the Companies Act 2013. Okay. Now comes joint. So when it was formed, it first initially 1850, 1857, 1860, 1866, 1930, 1936, 1956, and now comes 2013. So how 2013? See, only just you have to give a glance. This is very theory based. So 2013, you just have to learn these dates. I will tell you how. See, when the Companies Act 2013 received the assent of the President on which date? This is formulated. Can I remove this? I will remove this now. Then you can draw the table also in your module wherever you are writing down the notes. Yeah. So Companies Act, write down in the heading Companies Act 2013. First, right, you should be very presentable. Show the tables to the examiner so that you will give a glance. Don't write the paragraphs again and again. Presentation is very important to clear these professional exams. Yeah. So now comes Companies Act received the assent of the President on. So assent of President when received? August 29, 2013. Assent of given on this officially when it was notified officially in Gazette, notified in Gazette on August 30, 2013. This is how it will work. August 30, 2013. So when was Companies Act formed? When it came? How the Companies Act 2013 birth came? This is how. Assent of the President came on August 29, 2013. However, it was notified in the official Gazette on August 30, 2013. Okay. Hardly after 2 days. You can just write down this table. It's very important. So this table is very, very important for you. Just write down this table. So the assent of the President was given in August 2013 and notification gave in official Gazette on August 30, 2013. So this table is very important. You can just write down this table simultaneously in your module wherever you are writing. Then after that, so you just have to give a glance on this table which is written. You just need not have to cram this. But yeah, you should know. So when was the Companies Act formed? Basically in the year 1857. 1850 was the first year. Then simultaneously after that 1857, 1860, 66, 1930, 36, 1956, recently one, and now all the companies are formed in the year 2013. Okay. Yeah. So basically in 2013, what is happening? for encouraging the transparency and high standards of CG. What is corporate governance? Every company has to be properly corporate, they have to follow the governance principle. So for taking care of the governance principle, 2013 act was re-amended. 1956 was re-amended to 2013 act. Now, what are the important committees which are important for recommending these changes in Companies Act? This is also very theoretical, and you need not cram this, but yeah, you should know how to answer. So first of all, which committee was formed? There are total of 10 committees. Okay, first committee is Bhabha committee. You just have to write down the bullet points on this. If, for example, in your examinations a theory question come, name and explain which committees were important in formulating or making changes in the Companies Act. So first committee is Bhabha committee. We'll read down one by one. Okay, the government of India appointed a committee of 12 members. You can just highlight this 12 members representing various interests under the chairmanship of S.H. Bhabha to go into the entire questions of revision in Companies Act. So who was the person? Just highlight C.H. Bhabha. So this committee was formed by 12 members to go into the entire questions of revision in Companies Act. Fine. So next comes Shastri committee. Shastri committee, Government of India appointed a committee. Again, how many members? 6 members. Here 12, here 6. Under the chairmanship of Shri A.V. Viswastra Shastri to overcome such practical force to remove such drafting defects and obstacles as may be interfered. So first committee was Bhabha committee. Okay, don't cram it, just make it, put it in your mind like that way. Bhabha committee, 12 members under the chairmanship of C.H. Bhabha. Why? To go into the entire question of revision in the Companies Act. That whole Companies Act needs to be changed. 1913 Companies Act, officially the first Companies Act. Okay, second is the Shastri committee. Shastri committee, how many members are there? 6 members under the chairmanship. That was Bhabha committee under the chairmanship of C.H. Bhabha. Next is Shastri committee under the chairmanship of A.V. Viswastra Shastri. Only Shastri name, same name is coming to the committee name also. Okay, to overcome the practical, for example, to overcome the drafting defects as may be interfered. Okay, next is Sachar committee. What is Sachar committee? Committee was constituted by government under the chairmanship of Sri Rajendra Sachar. What is the person? Rajendra. To consider and report on what changes are necessary which are required to be made in the form and structure of the Companies Act. So what all changes are required in the entire form and entire structure of the Companies Act to simplify them and make them more effective. This is Sachar committee. First is Bhabha committee, Shastri committee, Sachar committee. Next is Chandrate committee. Chandrate committee was formed under the chairmanship of K.R. Chandrate. The main objective was to rewrite the Companies Act to facilitate a healthy growth of Indian corporate sector under the changing and highly so simply to rewrite this, for them is to rewrite. The third one, the Sachar committee, make some changes. Shastri committee, to remove the drafting defects. And first one is Bhabha committee. Okay, next come Iradi committee. Iradi committee was set up under the chairmanship of whom? Justice V. Balakrishna Iradi, consisting of expert to examine the existing law relating to winding up. See what he focused on: winding up proceeding of company. What is wind up? Wind up of the company. Wind up. There are two types of winding up of the company. First is the voluntary winding up, and second is the compulsory winding up. Compulsory winding up by the NCLT. Who is our appellate tribunal or for the companies? It is NCLT. Okay, National Company Law Tribunal. So winding up proceedings, how the company needs to be wind up, the Iradi committee what highlighted. Next is Joshi committee, constituted under the chairmanship of Shri R.D. Joshi to examine the remittance of the Companies Bill 1996. 7. Next is Naresh Chandra Committee was constituted in the government under the chairmanship of Naresh Chandra to regulate the private companies and partnerships. See, he highlighted on private companies. To examine the remnants of companies bill, who said Joshi Committee. Irani Committee was constituted under the chairmanship of J.J. Irani, Director Tata Sons, with the task of advising the government on proposed revisions in the Companies Act. How the revisions needs to be made, okay? Main things you just highlighted so that you come to know. For example, J.J. Irani with the task of advising the government on revisions. Fine. Then is Vaish Committee. Government of India appointed a committee under the chairmanship of O.P. Vaish to streamline the prosecution. See, prosecution mechanism under Companies Act to make it more. So, prosecution, what they highlighted basically on prosecution mechanism. Just a second. Prosecution mechanism. Company Law Committee has constituted Company Law Committee for examining, making recommendations to the government on various provisions, issues to the implementation of Companies Act. So, in provisions, to highlight on the provisions and issues of the implementation of the Companies Act, what committee was formed? Company Law Committee. Clear? So, first, fatafat, we'll just revise it out. First is Baba Committee. Baba Committee, how many members? 12 members under the chairmanship of S.H. Baba. What was the main motive of this committee? Basically to revise the Companies Act 1913. Done. Second, Shastri Committee. Shastri Committee constituted of how many members? 6 members under the chairmanship of Shri A.V. Viswanatra Shastri to overcome the practical force and to remove the drafting defects, okay, as may be interfered. Third is Sachar Committee under the chairmanship of Rajendra Sachar. What they said? What changes are required in the formation of the Companies Act 1956? They highlighted. Okay. Next is Chandrate Committee to rewrite the Companies Act under K.R. Chandrate to rewrite the Companies Act for the growth of corporate sector. This committee said. Irade Committee winding up under the chairmanship of what? Who is it? Irade Committee, Justice V. Balakrishna Iradi. Joshi Committee under R.D. Joshi to examine the remnants of the Companies Bill. Next is Naresh Chandra Committee, chairmanship of Naresh Chandra to regulate the private companies and the partnerships. So, Irani Committee by the chairmanship of J.J. Irani with the task of the government for revisions. How the revisions, why, and what is the purpose of making revisions in the Companies Act 1956. Next is Vaish Committee for prosecution mechanism. Vaish Committee was formed. Then and Company Law Committee basically for implementation of the Companies Act 2013 and LLP Act 2008. I hope you can very well, if any theory questions comes, you can just form this table highlighting how many committees are there, and then only one line is sufficient. Whatever I've marked is very important. Okay, so you can just mark if somebody has missed in the class to mark this important points, highlighting points. For example, here 12 members HC, then chairmanship mark this also Rajendra Sachar. Chandra Committee rewrite the Companies Act, mark this winding up word remnants of Companies Bill, private J.J. Irani, mark this basic words, prosecution mechanism Vaish Committee and the Company Law, mark issues implementation of Companies Act. Just mark this. I'll give you 1 minute of the time to mark all this. Highlight the important things in your module simultaneously with your whatever I'm saying and whatever I'm marking in my book online, you also mark in your book so that you don't get and don't waste your time in your revisions time to mark and just read. At the time of revision, you just have to see the highlighted points. That's how you will clear your professional exams. Okay. So mark this. I'll give you 1 minute of the time to mark everything. I'll go down the screen, just mark this. And after every lecture we'll make it a practice of revising what we have done at the end of the lecture. It's very good practice. Simultaneously, this is a good practice for your brain. At one time you will not be able to cram or learn the provisions. For me, the cram words is not suitable for your law exams, especially in your professional examinations like company secretary or chartered accountant course or CMA course, whatever course you're doing. For you people, multiple revisions are required. How things work in practical scenario, that is required. So this is how you can clear your exams. Yeah, I hope everyone has done this marking and all for this paragraph and all. Now we will start with we directly will come to here in page number 5. Companies Act stipulates enhanced self-regulations coupled with emphasis on corporate democracy coupled with following attributes. Now, what Companies Act has done? Let us see these 7 points. Business-friendly corporate regulation, pro-business initiatives. Business friendly corporate regulation. Now people are willing voluntarily to contribute and follow and comply with the provisions of Companies Act. There's one concept in Companies Act which is relating to corporate social responsibility. It is CSR. Okay, so with this CSR, this is apart from your activities, you're contributing to the social norms also of the society. With the Companies Act, this has come into enforce business friendly. People have become very business friendly in complying with the regulations. Second is protection of the monetary shareholders and investor protection and activism. Who are the investors? Who are the shareholders? Shareholders are the owners of the company who has invested in the company. So their protection needs to be done at very first. Paramount important for the company is important aspect is to protect their shareholders. Even if they are having the less stake in the company, minority stake is there, but still you have to protect it. By Companies Act, this has to enforce stricter enforcement and audit accountability. What is audit accountability? People now they are accountable for what they're doing, how they are doing things. So you also know that there is cost statutory auditor of the company, there is cost accountant auditor of the company. What is the function? Why the auditors? Why the concept of this auditor has come into enforce? So that what people are doing, what companies are doing, they are accountable of the things, accountable for their own accounts, accountable for their business, right? Next is enhanced accountability of management. Now management are also accountable to the higher authorities. Who are the authorities? The MCA, Ministry of Corporate Affairs. Enhanced disclosure norms. Now people, they are able to disclose, they don't companies are very vigilant in disclosing their what important information, even to whom? Shareholders, who are the owners, right? CSR, corporate social responsibility and better framework of insolvency regulation and institutional structure. So, like CSR provisions and better framework for insolvency, CSR has come into enforce, I already told you, through the Companies Act only. So this is people like management of the companies, they are more putting not only to do their business but also to contributing to the social aspects of the society. Good corporate governance. Again and again this word will come. Even there is a subject called corporate governance. Something corporate governance subject is there in professional old syllabus. Okay, so what all points are important after introduction of the Companies Act? What happened? First is business friendly regulation, protection of minority shareholder, stricter enforcement and audit accountability by management, enhanced disclosure norms, CSR and better framework for insolvency, good corporate governance. Okay, so I hope that you are clear with this. Just mark this in the module. So now coming to, just mark this all points first of all, shareholders who are the owners, then we can go ahead. Okay. Companies Act introduced new concepts supporting enhanced disclosure, accountability, better corporate board of the business and so on. It includes associate company, OPC, small company, dormant company, independent director, resident director, special court, secretarial standards, secretarial audit, class actions. All this is being covered in the Companies Act. Basically, accountability, good corporate governance, then CSR, corporate social responsibilities, independent directors, OPC, one person company. Who is the independent director? Independent director concept has come into fore after this Companies Act. Okay. Reforms board of for this is all three. We can read it. The enactment of companies allowed India to have a modern legislation for growth and regulation of corporate sector in India. The act enlisted with the changing economic and the business environment, both domestically and globally, to facilitate the business-friendly corporate regulations, improve corporate governance norms, enhances accountability on the part of corporate and audit, raise levels of transparency, and protect the interest of investors, particularly the small investors. See, investors who are the owners, those who have invested in the company, who has bought the shares of the company, you have to protect them. By this Companies Act introduction, particularly the small investors are given the protection. The objective of the Companies Act is to provide a business-friendly corporate regulation, proactive initiative, e-governance initiative, good corporate governance and CSR with the disclosure norms. Same points that you have marked there is written here. Okay. Then just a second. Okay. Stricter enforcement, audit, accountability, protection for minority shareholder, investor protection and shareholder activism, robust framework for insolvency and institutional sector. Initially, it seems a change in the Companies Act will brought out the significant changes in the manner of doing business in India. It becomes true when the initial unrest of the business community was taken by government and to address the practical difficulty faced by the business community upon notification of various provisions of the Act and rules made thereunder, and the term ease of doing business was popularized. How the ease of doing business become popularized? By this is how these points were taken care by the formation of the new Companies Act 2013. They have laid down so many important highlighters, important builders, pointers, which were very essential for the growth, not only for domestic growth but also for global growth as well for our India. Okay. Ongoing of is business front, the government of India has enacted a series of amendments, relaxation, exemptions, simplifications in various act, rules, regulations covering the business related issues, and this in series. The Companies Act 2013 is also amended to extend relief to the business entities governed under the Companies Act 2013. The amendments was brought through the Companies Amendment Act, Insolvency Bankruptcy Act 2016, the Companies Amendment Act, and the Companies Amendment 2019 and 2020. This all is what we have studied previously through the chart. They have just formatted in the paragraph. See, I have explained you, this is how the examiner will see. If you will make this a short and precise table, you will get 5 marks here also, and you will get maybe 4 marks here. Why? Because a examiner must be having so many papers. For them, understanding each and word to word, they have to read it in paragraph. It's become very difficult for the examiner. It does not look catchy also, not presentable also. Yeah, so make sure you add in the bullets instead. Now, very important concept, just write down in your notes. I hope everyone has written this. I will change some of the colors. Okay. Doctrine of ultravires. Very important. This is important concept in examination point of view. Doctrine of ultravires, it is a Latin words. Ultra sorry. Okay. How this doctrine of ultravires has come into effect? Just write it on, then I will explain you how is it. So two Latin words are there. First is ultra and second is vires. What is ultra? Ultra means in Latin it means beyond. What is vires? In Latin what it means? This phrase is used for authority or power. Any act which is done beyond your authority or power, that is called doctrine of ultravires. In this context, why this phrase has why this doctrine has come into effect, in fact, why? Because if the company is doing any act which is beyond its power, it will come in beyond its power or authority, it will come in doctrine of ultravires. For a company, logically when we think, for a company, what is beyond the powers? Beyond the act, anything you are doing beyond the act is doctrine of ultravires. Simple. Beyond the act or beyond any documents that a company has prepared internally, which is very important for a company. Before forming the company, there are very important documents that needs to be formed. For example, memorandum of association, articles of association. These are two words. I will write it down here also. For this, if any company reaches or do any act which is beyond important documents of the company, then also this doctrine of ultravires will strike. Okay, so for a company, for in a company's context, what do you mean by doctrine of ultravires? When you can say that a company has done any act which is covered under doctrine of ultravires, three of the things will come: important aspects, where this provision, not provision, you can say, where this doctrine strikes. Okay. Three situations. First, I will change the highlighter. So important aspects, you can just write it down. I'll give you 1 minute of the time. Beyond MOA full form is Memorandum of Association. AOA, beyond AOA, Article of Association. Beyond the Companies Act, whatever provisions are written in Companies Act, whenever you are going beyond this, these three situations will cover what will strike this doctrine. Okay, just make notes of this. What is MOA? It is important charter of the company. What is AOA? Important internal document of the company. So whenever the question comes theoretically also, facts of the case also, when you are writing case studies also, make sure to write this table. Very important to explain it in the table form and looks presentable also. Yeah. So let's come here. I hope everyone has done. You can I will just give you 1 more minute to just draw this table. Let's read now. Come to the module. Ultra is a latent term made up of two words. Ultra, beyond. Vires means power or authority. Okay. Ultra vires means any act that lie beyond the authority of the company to perform. I already told you this. Yeah. Any activity done in contrary to and in excess of the scope of the activities of Companies Act, MOA of the or AOA will be ultra vires. So three things came. Write down 1, 2 and 3. Here we have done 1, 2, 3. Ultra-vires activities can be divided into following three divisions: ultra-vires the companies, MOA and AOA. Clear? Now first comes ultra-vires the Companies Act. Let's read this. The power of the company is right from the law governing it. See, company law, how companies power comes? It comes by law. Who governs it? Section 6 of the Companies Act expressly provides that the provision of the Companies Act shall prevail, notwithstanding anything to the contrary contained in memorandum or articles or an agreement executed or any resolution passed by the company in general meeting or BOD. Whether the same can be registered, executed, passed, or as the case may be before or after the enactment of the CAR. When this Companies Act came into picture, what was the exact language that was used? Whatever is written in the Companies Act, whatsoever it is written in MOA or the A of the company, nevertheless, any resolution is passed by the shareholders of the company who are the owners of the company, any resolution which was passed by the board of directors of the company, it has no power up what is written in the Companies Act. Simple. Who is the supreme power here? Companies Act. This Companies Act is above all the MOA, AOA, resolution passed by the shareholders, resolution passed by the board of directors. Anything contrary to the act means anything, whatever it is written, nothing, this line cannot be changed. Simple. In simple layman language, okay? So, it shall prevail notwithstanding, irrespective of anything which is written in MOA, AOA or whatever it is, but still this will come into effect. Clear? Any act done contrary to in excess of the scope of the activity of the company will be ultra vires the Companies Act. Such an act is void and cannot be ratified by even by unanimous resolution by the shareholder. What do you mean by unanimous resolution? Unanimous resolution is passed by all. Even if it's passed by all the shareholders, approved by all the shareholders, that time also this particular act cannot be. It cannot be. It is not voidable. It is void. It is null. Simple language, null. Cannot be ratified, cannot be changed. Okay. For example, if board of director appointed or removed without following the statutory provision, payment of dividend out of the capital or reduce the share capital without complying with the legal formalities, then this will cover. Suppose if you have appointed the board of directors without following the provisions of the Companies Act, if you have increased your share capital of the company without following the provisions of the Companies Act, then this doctrine will what come into effect. But you can say, yes ma'am, but still in MOA it was written like this, AOA it was written like this, but this is also passed by all the shareholders, approved by the shareholders or the owners of the company. No, I will say no, irrespective of anything what is written in your MOA, irrespective of anything which is written in your AOA, and also irrespective of any resolution that was unanimously passed by all your shareholders, you don't have the power above what is written in your Companies Act. I hope you're clear with the point. It also declares a provision contained in MOA if it's repugnant to any of the provisions of the, if it is not following the provisions, if it is what you can say, it is contradicting the provisions of the act, then this doctrine will follow. Okay, ultra vires the MOA. Second thing come ultra vires the MOA. MOA, what is it? MOA is the document listing out the constitution of the company, essentially represents the foundation stone on which the structure of the company is built. It contains the clauses detailing the boundaries of the Companies Act and relations with the outside world. So, in MOA, there are certain foundation is covered, clauses are covered. When we speak MOA, important clauses will be covered, foundation of company. What do you mean by clauses? Clauses can be object clause, capital clause, name clause, situation clause. Wait, I'll just remove this so that there is no interrelation between these 2 points. Name, situation. So object, name, situation. There are some of the important other clauses also, but for you, you're just beginning with this chapter, so I don't want to write all the clauses, but these are very important clauses. So in MOA, what is it written? There are some important clauses which are written and which is a very foundation of the company. For it's important for which the through which the foundation of the company is built. You can just write it down. So important attribute of MOA is considered to be its object clause. See, very important clause. Section 4(1)(c) of the Companies Act. See how you will read this. Section 4, subsection 1, clause C. This is always subsection. First bracket is subsection. Second bracket will clause. And then if after this also one bracket come, it will be subclause. Okay. So this is called, you can write down subsection clause. Companies Act requires every company to state in their MOA the objects for which companies propose to be incorporated in any other act considered necessary in furtherance of thereof. So this is very important clause. So what will be the, what logically when you think as a layman, what can be written in this object clause? Basically in this object clause, what is written means what is the object of the company? Is it into the pharmaceuticals? Is it into the mining? Is it into the construction? Whatever objects for which this company is formed, it is written in this object clause. So what is the section of this object clause MOA? Section 4, subsection 1, clause C. MOA of the company restrict the powers of the company while defining the object of the company. The company cannot do anything which is beyond the purview of the object clause. I cannot do anything which is beyond my purview. For example, I have formed a company which is into the mining, but I am doing the business of the pharmaceuticals. It is not within my scope. So I am doing this doctrine of ultravires and I will be liable for this. Any act done in contrary to the object clause of the MOA will be ultravires the MOA of the company. In case of the company, whatever is not stated in the MOA as the objects or powers is prohibited by doctrine of ultravires. As a result, any act which is ultravires is void, it is null and does not bind the company. Neither the company nor the contracting party can sue it. Such an act is void and cannot be ratified even by unanimous resolution by the shareholders. So very, very important it is, this line. I hope you are clear. So whatever it is not written in your MOA and you are doing any act which is beyond your MOA, that particular act will be ultra vires and it is void, it is nullified, this act is nullified. Even if you will ratify this, you will change this by unanimous decision of all the shareholders, still it is void in the context of law. So you can write down in your notes. And can't be ratified. Okay. ultravires the AOA. Section 5, Section 1 of the Companies Act, AOA of the company shall contain the bylaws, regulations for the management for the internal affairs of the company. So, AOA is nothing. Just a second. Sorry. I hope you have written this. Next comes AOA, okay? What you have written? AOA Section 5, Section 1, AOA of the company shall contain the bylaws and regulations of the for the management of the internal affairs. Bylaws, rules for management for this AOA is formed, okay? Governing, it plays a vital role in governing companies if it defines the rights of the members inter se. Rights. So what is the function of AOA? AOA bylaws and the rules. It is an important document with respect to the bylaws and the rules with respect to management for internal affairs of the company. For the management for internal, how the internal affairs of the company can be managed, it is written in AOA. And also, what are the rights of the members inter se amongst themselves? What are the rights? Now for here, who are the members? Members can be board of directors of the company. Members can be shareholders of the company. What are their rights also? Right? So these are the rights of the members amongst them. Inter se means amongst them. Then if a company acts which are ultravires the AOA but intravires the MOA, that is outside the beyond of articles but within the purview powers conferred by MOA will be ultravires the AOA also, right? Suppose if the particular act it is ultravires the AOA but intravires, it is within the MOA, that is outside the scope of articles but within the powers conferred by MOA, then also it will be ultravires the, this is also ultravires the AOA. That is payment of interest on advance payment at a rate higher than allowed by article. These acts are also what, but the company general meeting may alter the acts by special resolution, ratify the unauthorized act. See, if any act, particular act, we take an example, it is ultravirus, understand the situation, okay? The AOA but intravirus within the scope of MOA. It is then also ultravirus act, okay? Ultravirus of MOA, okay? But you can ratify. How? By unanimous resolution by, okay? So this is a situation of suppose any act which is ultravirus the AOA and intravirus the MOA. MOA ke within but ultravirus out is outside the AOA, it is still ultravirus act. But yeah, though you can ratify it by unanimous resolution by shareholders, says this particular act is not void. It is voidable. Okay, it is not void, it is not nullified act. You can ratify this particular act. You can just write it down. Now one case law has come. In RE South Durham Bureau Company, the MOA of the company was unclear as to the classes of the shares to be issued by it. But AO of the company gave power to issue shares of different classes as described therein. The Honorable Court held that articles can be used to explain the ambiguity contained in the MOA. So you can refer the articles if there is any sort of ambiguity, you are not clear with the provisions, you can always refer AOA. To explain any ambiguity appearing in the terms of MOA, to supplement it or to upon the element to which is silent. Also as stated earlier, in every member is perform. This is another case law, just for your reference. The rule is meant to protect the shareholder and creditors of the company. So why is this rule is made? To protect the shareholders and the creditors who have given the money to the company. If the act is ultra-vires beyond the powers of the directors, only the shareholders can ratify it. If it is ultra-vires the AOA, the company can alter its AOA in proper way, and thereby such acts can be duly ratified. That is said. So what is the case law you have studied? RE South Durham Bureau Company. Okay, this you can write down this case law also. It's very important. So this is the second case law. Case laws we'll study for the next class, because otherwise it will be very boring. Okay, so we have studied ultra-vires the AOA, ultra-vires the MOA, ultra-vires the article of association. So this will be first, second and third. Okay, you can just mark it. I'll give you 1 minute of the time to mark this AOA wala thing also, then we can go ahead. Okay. So now coming next to next point. This case laws we'll study in the next lecture. Loans, borrowings, guarantees and ultra vires rules. Just a second. Okay. Loan, borrowings, guarantees, and ultra vires rules. And ultra vires borrowing does not create a relationship of a debtor and creditor. If any ultra vires comes beyond the powers, the debtor and creditor has any relationship. No, logically they don't have any relationship, right? So an ultra vires borrowing does not create a relationship of a debtor and creditor. In a case, a company had accepted deposits from outsiders. Something you have accepted from outsider, which was outside the scope of MOA. When the company was ordered to be wound up, a question was raised whether the depositors were creditors of the company and whether the contributors could be asked to contribute towards the payment of the deposits. The court held that the relationship between the company and the depositor was not that of a debtor and creditor, but if a lender had lent the amount for discharging the lawful expenses, he may recover it. For example, there is a case which is going on and the company has taken that case expenses from any of the creditor from outside. In that case, he may recover the amount only for that case. This is an exception. But yeah, if a company has they have entered into some sort of transaction, there is some sort of transaction between a company and one of the creditor who has given the money to the company, but that money which was given, for what purpose it was bought, it was outside what was written in your MOA, then this relationship is not in existence as per the law. There is no relationship as per the law between a creditor and MOA, and no party can sue in this case. Means no party means creditor cannot sue the company to recover the money. Hope it clears. Whether the transaction is ultra vires, the company can be decided on the basis of the following. What is the basis? If the transaction entered into by a company falls within the object, it is not ultra vires and hence and not void. But if it within the object, it is not ultra vires. Outside the object, it is ultra vires. If the object is in excess or abuse of the company powers, it is ultra vires. Transaction which is can be set aside by the shareholder or even ratification by shareholder would not validate the acts done beyond the authority of the company itself. So in three situations you can see which is entered, which falls within the scope of the object, then it is not ultra vires. But if it is done beyond the object, it is ultra vires. If it is in excess or abuse of the company's powers, then also it is ultra vires. Even if you can ratify it, it's still otherwise. Okay, then is implied powers. Under the powers exercised confined to the objects in the MOA. MOA, you have read, object clause is very important. The MOA, subsection 1 clause, right? Then comes this one. While the to be specified accessible in respect of express or implied. Specifically, you can express the powers, or impliedly people can make them understood. Yeah, if the company is into the pharmaceuticals business, then obviously they will sell pharma products, they will make pharma products. If it is into the mining or the construction, then mining mining products will be made and it will be sold, it will be purchased, whatsoever it is. Yeah. While the objects are to be specified, the powers exercisable in respect of them may be expressed or implied and need not be specified. Every company may be necessarily possess certain powers which are implied, such as power to appoint and act through agents, and where there is trading company, a power to borrow and give security. See, Whatever is your business, you have to do. This is simple. Suppose your company is into trading, so the power to borrow and give security for the purpose of its business and power to sell. Such powers are incidental and can be inferred from the powers expressed in every way. The principle underlying the exercise of such power is that a company, in carrying out the business for which it is conscious, must be able to pursue those things which are regarded as incidental or consequential upon it. It is incidental or to your business, obviously you have the power to do it. Is though it is not defined in your MOA, it is not defined in your AOA, but impliedly you have to do in order to make forward your object of the main objects of the company. Then you have to, then this is implied powers which are not implied. What sort of powers are not employed? Following powers had held not to be implied and therefore prudent to include them expressly in the object clause. Acquiring any business similar to the company's own business, entering into agreement with other person of the companies for carrying on the business in partnership or sharing. For example, first point, acquiring any business which is similar to the company's own. अपनी कंपनी का, खुद की कंपनी का, मीन्स आर ओन कंपनीज बिजनेस इज इनटू फार्मास्यूटिकल्स एंड आई एम डूइंग सिमिलर लाइन ऑफ दैट बिजनेस, सिमिलर लाइन ऑफ द बिजनेस, फॉर एग्जांपल दैट विल बी द कॉम्पिटिटर obviously, but still if I am into pharmaceutical business where I am sending a particular trademark for which I have made a registration, in that point of point, if any other party does the same business, then it comes under this. Okay, entering into an agreement with other persons or companies for carrying business in partnership or sharing profit, joint venture, where powers are necessary to justify such. For example, whatever agreement you have entered with the other persons, with other companies for in partnership or sharing profits, so very clear powers need to be justified for this. Taking shares in other companies having the similar objects, you're taking shares in other companies which is having your similar objects, then also uses void. Then void means which is not implied. Okay, taking shares of other company where such investment authorizes the doing indirectly that which will not be improvised if done directly. Promoting other companies or helping them financially. A power to sell, dispose of all of the company undertaking also comes under the implied powers, not implied powers, sorry. The power to use funds for political, power to power to give gifts and make donations or contributions for charity not relating to the object which is stated in your MOA, it is not implied. Acting as surety or as a guarantor. Quickly underline this, then we will just wind this portion to move ahead. So what all the powers which is not implied? It's first is acquiring any business which is similar to your company's own business. Second is suppose you have entered into an agreement with different companies or the partners, then for sharing the profit, and you have not defined, it is not the powers which is implied. Next is when you took shares in other companies which is having a similar objects, then taking shares of other companies where such investment authorizes the doing indirectly that which will not be improvised if done directly. Then promoting the companies or helping them financially, then also it is not implied powers. The power to sell and dispose of all of the undertaking, then also power to use funds for political purpose, power to give gifts, donations, contribution for charities not relating to the object stated in the MOA, and act as a surety, as a guarantor. I hope you are very much clear with this. Moving ahead, shareholder right in respect of ultra-vires acts. What is the shareholders rights? What are the owner's rights if any act which is done by company it is ultra-vires? A shareholder can get back the money paid by him to the company made under ultra-vires allotment of share. A transfer of shares from him would not have been so allowed. So he can just claim his money back. Effects of ultra-vires transactions. So there are some of the effects. to ultra vires provisions. Let's come to this ultra vires transaction. First of all, it is void ab initio. What is meaning of this? Void ab initio. Void ab initio by the phrase means it is void since its inception. From the beginning, this particular act will be void. The ultra vires acts are null and void ab initio. The company is not bound by these acts. So, nobody is bound by such acts. Even if a creditor who is given the money, but such act is ultra vires the objects of the company, he cannot claim the money. Even the company cannot sue or can be sued upon. Ultra vires contract are void ab initio, hence can not become intra vires by reason of estoppel or ratification. Estoppel or ratification, there are two principles. You can change the particular phase by putting the doctrine of estoppel or doctrine of ratification, but these two doctrines cannot be applied in this ultra vires acts. Next is injunction. The members can get an injunction to restrain a company where an ultra vires act has been or is about to be undertaken. So they can get an injunction, they can claim, they can instruct the company to restrain they can restrain the company from doing such act. Personal liability of the directors. It is one of the duty of the directors to ensure that the corporate capital is used only for the legitimate purpose of the company, and hence if such capital is diverted to purposes alien to the company's MO, the director will be personally liable to be replaced. Simply you will write, you will not just have to go to the paragraph. Simply I will explain you. Any act which is ultra vires, directors are personally responsible for this. Why? Because they are the management of the company. They have to think before what company has to undertake. They are the management, they are the main head of the company. So any act which is done by this is obviously their personal liability, that this particular act was done ultra vires and they will be personally liable for this, right? Where the company money has been used ultra vires to acquire some property, the company's right over such property is held secure and the company will be right party to protect the property. This is because though the property can be acquired for some ultra vires, it represents the money of the company. For example, a particular company's money has been used, okay, which is ultra vires to acquire some property. So the company right over such property is held secure. Company's own right is held secure in such property, and the company will have a right party to protect the property. But see, if though the property has been acquired for some ultra vires object, but it still represents the company's money. Ultra vires borrowing does not create a relationship of debtor and creditor. Ultra vires torts. A company will not be liable for the torts. Torts means mistakes. A company will not be liable for the torts committed outside the observer. In order to make the company liable for torts or crime of its employee, it will have to be proved that the tort was committed in course of an activity which is in purview of the company's MOA. It was committed by the employee within the course of the employment. See, so you have to take care of this point. This is ultra vires torts. Torts means mistakes. Company will not be liable for torts which is committed outside its object. Mistakes which is committed outside its object. In order to make the company liable for the torts or crime of its employees, one has to prove 2 points: that the tort or the mistake was committed in the course of the activity which is in the purview of the company's MOA. This tort has to be proved that it was done within the objects of the MOA. Secondly, it was committed by the employee which is in the course of the employment. Next is ultra vires grants and grantees. Directors cannot be make an unauthorized grant unless the object to promote prosperity of the company or the grant is incidental to carrying on the object of the company. A guarantee for the payment of dividend which enables the guarantee to bring an action against the company for reimbursement even though there are no profits, it's ultra vires. And so directors, they cannot be make an unauthorized agent to unless the object is for prosperity. They cannot made a guarantee for anything. Okay, it has to be within the purview of the object of the company. So these are some of the points that you have to remember. First, quickly we'll just recall it. What are the effects of ultra vires? It is void ab initio, void form, inception. Injunction, you can restrain. Personal liability of the directors, they are liable for it. Then ultra vires of to acquire some property, the company's right over such property has a company will have a right to protect the property wala point you can just mention. Then no relationship between creditor and debtor. Torts, if you have to prove company will not be liable for the tort committed outside object. In order to make the company liable for the torts, you have to prove 2 points: that it was within the company's MOA, and second, it was committed by the employee, which is in the employment of the company. Next is ultra vires grants and guarantees. There is no guarantee or grants which is ultra vires the object of the company, but yeah, the director being the high level of the company, they cannot give the guarantees blindly. It should be given within the objects of the company. Now, coming to what all can be exceptions of this doctrine. What exceptions? Exceptions means exceptions. What do you mean by exceptions? Exceptions is basically what are if even if you are doing the acts ultra vires, what some of the points can still it can overcome the ultra vires acts. Okay. First one is any act which is performed irregularly, but otherwise it is intra vires the company. It is not done regularly. It is done irregularly. Sometime it is done, but otherwise which is intra vires the company, it can be validated by the shareholders by giving their consent in the general meeting. So one general meeting is the meeting which is conducted by all the shareholders, who are the owners of the company. They conduct the meeting by general meeting, and who are the board of the directors, they conduct the board meetings. You will understand in the next chapters. So any act which is done irregularly, but otherwise which is intra vires the company, and suppose is intra vires the company, that act, it can be ratified by, or it can be validated by the shareholders by giving their consent. Consent, do you mean, what do you mean consent means? Agreeing in the shareholders general meeting, then such act is an exception. Exception means over and above what is written in ultra vires act. Second is, if any act is deemed to be within the authority of the company by the company's act, then they will not be considered as the ultra vires, even if they are not expressly stated in the MOA. So second point will be if any act which is deemed to be, it is implied to be within the authority of the company by companies act, then they will not be considered as ultra vires. Third point, any incidental or sequential effect of ultra vires act will not be invalid unless the companies act expressly prohibits such act. Expressly it is prohibited by act, then it will be ultra vires. If it's not prohibited by, then it is not ultra vires act, right? So any incidental or consequential effect of ultra vires act, right? Any act which is outside the authority of the directors of the company, but otherwise it is intra vires the company, can be ratified by the shareholder of the company. Though it is ultra vires the directors, it is outside the directors of the company, but it is intra vires the company, it can be ratified by the shareholder. Those shareholders, their authorities, it has been defined, but whatever act has been done, it is outside their authority, but still it is intra vires the company's object, then also you can ratify in the general meeting of the shareholders and make this an exception to the ultra vires act. So there are 4 points which are covered. First of all, you will write like this, so that it is easy for you to people to irregular act, deemed act, right, incidental, effect of ultra vires, and any act which is, just a second, authority of the directors. 1, 2, 3, 4. Clear? Let's write down these points quickly. So this is all about doctrine of ultra vires. This is very important portion. I don't want you to just just cram this whole portion. Whatever we have done, it's sufficient for today. Let's wind up what we have done in ultra vires, and then we can wind up this lecture. Coming to our notes, first of all, doctrine of ultra vires, chapter number 1, we can write it down here. So doctrine of ultra vires, it has derived from the Latin words quickly. Ultra means beyond, virus means what? The authority and the power. What are the important aspects where this doctrine strikes? When this doctrine can strike, when it can hit? The important aspects are 3, which is beyond the MOA, which is beyond the AOA, and which is beyond the Companies Act. What is MOA? MOA is the Memorandum of the Association of the company. What is AOA? AOA is the article of the association. What is covered in MOA? MOA is a very important charter of the company. Few clauses of the company are covered. For example, what clauses are covered? Object clause, capital clause, situation clause. Some of the clauses are object clause, situation clause, capital clause, name clause. What is situation clause? Where it is situated. What is name clause? What is the company's name? What is the capital? How much capital the company has put into? And what is the situation clause? Where is the situation comes? Situation done. Name clause done. Then capital. What is how much capital this company has invested to run a business, particular business? Then is the name clause. What is the name of the company? Is it identical to some other name? No, it is not. It's come in the name clause. Then is beyond the AOA. It is an important internal internal document of the company, important charter of the internal document of the company. Internal, how the company affairs will be managed, it will be written in the AOA. Then come MOA. MOA is the important charter of the company. Now in MOA some clauses are covered. I have told you before also. So what is MOA? MOA is basically the foundation of the company. Act which is ultra. Who is above? MOA or AOA? MOA is always above. Then comes AOA. Okay. And what comes above MOA and AOA? It comes the provisions of the act. Okay. Act which is ultra vires the MOA, it is void and it cannot be ratified. Even by unanimous resolution by the shareholders in, you can write in general meeting. Okay. Next comes AOA. AOA, what are this? This is bylaws, this is rules, these are rights. Rights are defined of the members here. Who are the members here? Members may be the board of directors, executives of the company, management of the company. So managing the internal affairs of the company, AOA is formed. MOA is basically formed for outsiders. AOA is basically formed for internal people, right? So amongst them, this AOA and MOA comes. Quickly, MOA is, what is it? Clauses are covered. It is the foundation of the company. So any act which is ultra vires MOA, can you ratify it? No, it is cannot be ratified. It is void. Simply it is what? It is void. Then what is AOA? Any act which is ultra vires AOA but intra vires MOA, yes, it can be. It is it void? No, it is not void. We can ratify it by unanimous resolution by shareholder, not void, right? So for example, we have written MOA and AOA examples also we have written. You just go through this MOA and AOA example. So any act which is ultra vires the MOA but intra vires the AOA, is it void? Yes, it is void. Why? Because it's ultra vires the MOA. Now any act which is ultra vires the AOA but intra vires the MOA, is it ratified? Yes, it can be ratified. By how? By unanimous resolution by shareholders. Why? Because bigger authority is MOA, then comes AOA. Above both of them come Companies Act. Then so this was it. Then quickly we'll see first we'll cover this MOA and so what we have done doctrine of ultra vires, 3 aspects we have covered and then nullified. Then MOA object clause is covered in section 4 subsection 1 clause C. Then comes ultra vires the AOA. Which section it covers? Section 5 subsection 1 is AOA. One case law we have studied, case law is South Durham Bureau Company, where it was simply written that MOA was unclear as to the classes or the shares which to be distributed, but AOA defines it. But you can honorable court decided that you can take the reference from AOA if something is not defined in MOA, right? Then comes there were certain loan borrowing guarantees and ultra vires rules also. So there are some of the situations where you can define an ultra vires transaction. If a transaction it is falling entered by a company falls within the object, it is not ultra vires, but it is not void, it is within the objects. But if it falls outside the object, it is always ultra vires. And if it abuses or excess of the objects is used, then it will be ultra vires. Such transaction will be, it can be set aside. It can be set aside by the shareholder. It can be ratified if excess or abuse of the company is. So it is ultra vires and it can be set aside. Was not employed. What were all powers? For example, acquiring any business which is similar to company's own business, entering into agreement with the companies or companies carrying on the business in partnership, or what, sharing profits. Very clear powers are necessary to justify such transactions. Taking shares, when you are taking shares in other companies having similar objects, then taking shares where such investment authorizes of doing indirectly, that will be not be intra-vires if done directly. Promoting other companies or helping them in financially. Then power to sell or dispose of the whole of the undertaking. Power to use the funds for political purposes. Power to give gifts and donations or charities not relating to the objects, acting as a surety or as a guarantor. Such powers are what? These are not at all implied. These are not incidental or consequential. Simple. Then comes shareholder right for ultra vires acts. What we have studied for shareholder rights? Yes, they are the owners of the company. They have given money to the company. They can be paid. It is the duty of the company to pay them. Why? Because they are the owners of the company, even if the company has done the ultra vires act. Okay. So what are the then we have studied what effect of ultra vires transaction. First example, it is void ab initio, it is void from inception. Injunction, somebody can restrain the company from doing such ultra vires act. Next is personal liability. Each and every directors have to be personal liable for such acts. Then where the company has been used ultra vires to acquire some property, if anything is done to acquire the company's property, then the company definitely can protect that property. Why? Because it is from the own business of the company, right? Then ultra vires borrowing does not create any relationship between the creditor and the debtor. Case study can come. Suppose I will give you a situation. If suppose a creditor has given some 1 lakh or 2 lakh of the penny amount to the company, he is a creditor of the company in your books, but that money is used for one of the object which is not covered in the object of the MOA. So definitely it will ultra the MOA. Any act which is ultra vires the MOA, it is void ab initio from the inception. So this will not create any sort of relationship with the debtor. Next is ultra vires tort. We have studied company will not be liable for the torts or the crime which is committed outside object, but you have to prove any of the mistake or any of the tort or any of the crime of the company. Two things you have to prove: what tort was committed in the course of any activity which is in the purview of the company's MOA, and secondly it was committed by the employee during his employment. Then also the company can be held liable. Ultra grants and company for not give what ratio of the debtors, then ultra vires property point, then comes relationship of the debtor and the creditor point, ultra vires torts, ultra vires guarantor. And this, what are the exceptions? We have studied 4 of the exceptions. If any act is irregular but otherwise it is intra vires the company, it can be validated by the shareholders in the general meeting. by passing the resolution unanimously. Second, which is deemed to be within the authority of the company by the companies, then they will not be considered as the ultra vires if it is not expressly stated in the MOA. Then any incidental or consequential effect of ultra vires act which is not invalid unless the Companies Act expressly prohibits such act. See, Companies Act comes above authority. I told you the more supreme authority is Companies Act. So any incidental or consequential effect of ultra vires act will not be invalid unless the Companies Act expressly prohibits. Any act which is outside the authority is intra vires the company can be ratified by the shareholder of the company. Outside the it is intra vires the company. Okay. I hope you've written these points. Deemed act, intravise incidental effect of ultravise authority of the directors. Okay. So this house we have completed as ultravirus wala portion that we have studied today. So after introduction of the Companies Act, what we have started? After introduction of the Companies Act, there are some of the important points that come into enforce. For example, what? Business friendly corporate regulation has come. Protection of minority shareholders, their protection has been given. Stricter enforcement, audit accountability has come into. Enhanced accountability of management, enhanced disclosure norms has come into effect. CSR and better framework has come into enforce. Next one is good corporate governance. So what all committees have recommended what changes to the Companies Act? First was the Bhabha Committee. Bhabha Committee consisted of 12 members under the chairmanship of CH Bhabha. What was the motive of this committee? Question revision of the Companies Act 1913, the initial act. Next is Shastri Committee. 6 members under the chairmanship of A.V. Viva Shastri to overcome the practical force, to remove the drafting defects basically. Sachar Committee, Rajendra Sachar under the chairmanship, changes required in the form or the structure of the Companies Act to simplify them, basically to simplify them. Sachar. Clear? Excuse me. Next comes Chandrate Committee. Chandrate Committee to rewrite the Companies Act to facilitate the healthy growth. Then is Irade Committee under Balakrishna Irade, consisting of the experts. Why? Relating to winding up. Then is Joshi Committee. Joshi Committee to examine the eminence of the company's bill. Then is Naresh Chandra Committee. Naresh Chandra committee was formed. Naresh Chandra to regulate the Private Companies Act partnerships. Next comes the Irani Committee. Irani Committee was J. Irani with the task of advising the government on the proposed revisions of the Companies Act. Vaish Committee, prosecution mechanism, to see the prosecution mechanism of the companies under the Companies Act. Company Law Committee to see the provisions and the issues for the implementation of the Companies Act 2013 and LLP Act 2008. Then simply we have studied initially Joint Stock Companies Act was formed 1850, 1857, 1860, 1866, 1930, 1936, 1956 and 2013 to focus on CG. So important committees 1913. So this committee, Bhabha Committee, highlighted on which act? Basically 1930 Act. Okay, this is interrelated. So this is how we have studied so far. MOA is very important aspect of this your syllabus. It's better you what is the tactic to study. I am like I hope so that I'm able to explain how you have to study. You need not understand whole paragraph. Simply make it what all provisions can be covered in this. Firstly, summarize that, make it a bullet points, understand the bullet points again and again. This is how it will happen. Whenever lecture is concluded, we make it a habit of revising what we have done. You will be able to learn, and you will be able to revise the concepts which we have studied at the end of the day. Yeah. So apart from this, I would like to tell you one more thing. We will start marking the tick marks here in the index also for our reference, what all portions have been covered in the particular chapter that we are doing. Yeah, just a second, bear with me. Introduction, history is done, important committees is done, concept paper, companies act, reforms and ease of doing business by CG, doctrine of ultravirus, effects, exceptions of ultravirus. Now next we will start with doctrine of indoor management. Okay, clear? Then apart from this, I would like to tell you, so this is the first thing. This is the second thing, that we have to study AOA, MOA and alteration, how you can alter these MOA and AOA. This is very important. Share capital, this second will cover this. Then general meeting and composition, you can write down very, very important chapters for this. This you can highlight, these are important ones. Yeah. And also during my classes, at the end of the classes, we'll make sure you will buy a name called scanner. See, scanners are very important to crack the professional examinations. Why? Past year questions, past year papers are covered in the scanner. So scanner is a very important thing. At the end of the classes, we'll make sure we'll purchase this book called Scanner. Many authors, they have, it's basically, it is past year questions. You will come to know how the questions are framed. So I'll give you 5 minutes of the time to just write down this notes. If somebody has missed, I can just write it down. You can wind up. Make sure to write each and every word. Don't miss anything, students. I hope you are able to see it. These are all handwritten notes. You can ask the academy, Ramesh Academy, to issue handwritten notes if you require. But yeah, simultaneous. It's better you write it simultaneously so that you can learn and you can revise at the end of the day. Yeah. Make sure to write this. This is very important. And also to mark. Done, everyone? And also do mark this all things also index. Everything is marked, I guess, by all you people. Make sure to mark and highlight the words specifically what is highlighted by me. Yeah? Coming to this, just make sure to highlight the important words, whatever has been bracketed by me specifically. Just highlight the portions that only it will help you at the time of the revisions. Okay. Case laws, make sure tomorrow will just do the case laws also, important case laws basically. Let's write down these points, bullet points. So from tomorrow we will start with the rest of the chapter, and apart from that rest of the chapter. Okay, see you students for the next class. Hope you have enjoyed this class here.